Hey everybody, my name is Nick. I am the Communications Director here at Arlington Community Foundation. As you may or may not know, it is National Make a Will Month in August. And in preparing for doing some promotion around National Make a Will Month, I realized that I myself, embarrassingly enough, do not have a will. So I thought that this would be a really good opportunity to talk to an expert about the subject for myself personally to learn, and then also to share that with anybody who's watching this who might not have a will, might be thinking about one, might be hesitating to make one, and hopefully I can get my own questions answered, and then see how that goes. So without further ado, I want to introduce our very special guest, Drew Murray. If you want to tell us a little bit about yourself.
Sure. I've been in practice now for about 12 years with Manning, Murray, and Baxter here in Arlington. We do estate planning and estate and trust administration. So that's all we do. We have a pretty narrow focus, but you'd be surprised at how interesting things can get and how many issues actually are in this field of estate planning. I'm sure we'll dig into some of them.
I had some questions about some of the more interesting cases, if we could talk about it. So we'll see if we get to that. So, going back to wills, my first question is, what happens if I don't make a will? Why do I need a will? For my personal circumstances is I'm not married. I don't have any kids. I have a wonderful dog who I would leave everything to if I can. I don't know if that's something I can do with my will. Excellent. Could. Yeah. So both for me and for anyone who doesn't have a will, what happens if we don't make one?
Yeah. And I think in the spirit of Make a Will Month, when we talk about making a will, it's really the broader context of what is estate planning, right? And a will can certainly figure into that. But things like beneficiary designations on your accounts, you might have for a bank account, you might have listed that with the bank, POD, pay on death. So that account is payable on death to someone, and that's an agreement with the bank that they're going to pay it directly to that person you named as soon as they can fill out the forms with your death certificate. So that's a mechanism to pass an asset of yours that doesn't even involve the will at all. So a will is kind of there for any assets that didn't pass by beneficiary designation or weren't in a trust or didn't have survivorship on them. So survivorship, you're on an account jointly with someone and one of the owners passes away and the other automatically owns it because the account was joint with survivorship. So part of planning, one might be making a will, one might be let's look at all your beneficiary designations on all of your accounts. In Virginia, you can even do that with real estate with a special kind of deed. So it's more of an overall plan, right? It's make your estate plan month would probably be more apt than make a will.
Make your estate plan month.
But what happens if you don't have a will, you don't have any beneficiary designations on all of your accounts? Well, so the scary word is probate, right? Virginia, fortunately, is one of the easier places to administer an estate because there's not a formal probate court. So it's kind of a very informal, we call it a commissioner system. So every county and city in Virginia has a commissioner's office and they're overseeing the executors or the administrators who are dealing with assets. But that's not to say there's no work involved. So if you passed away, you have a bank account and it didn't have a beneficiary designation on it, and the total amount of your assets, total value, exceeded $50,000. You have to have someone, which we call an administrator. It's kind of the equivalent of an executor, but where there isn't a will. But it's very similar, and it's the same process. And so you would make an appointment with the county. In your case, are you in the city of Alexandria?
I'm in Alexandria.
Yeah. So they've got their own commissioner system. You make an appointment with actually at the courthouse at their probate office, and someone, a family member, would qualify as administrator. And they would get the authority from the court in the form of an actual piece of paper. So we call it a certificate of qualification or letters testamentary. And they can take that piece of paper and contact the bank and fill out their paperwork to bring that asset into the estate. So the downside is, in exchange for the court giving the administrator that authority to deal with the assets that you had, the court now has the responsibility to oversee what happened with those assets. So they're going to actually audit. This is where the commissioner comes in, audit all of the activity from when it came in, balanced to the penny, to when it was fully distributed to where it was supposed to go. So where the will comes in versus not having a will is, with a will, you get to say where it goes, or with a trust. In the absence of that, Virginia law says, here are your heirs at law. And it's kind of, if you don't have a spouse or children, it's your closest living blood relatives. So it goes parents, otherwise siblings, otherwise nieces and nephews. Otherwise, it goes up to grandparents, aunts and uncles, cousins. And so there's always someone. So there's always a blood relative. But say you had your pet and you wanted to take care of, you would want to specify that. Otherwise, everything's just passing to your closest relatives, and you're going to hope that they do the right thing by you.
And I will specify that for sure.
Yeah.
Not your first time talking about this, I feel like.
Pets are a big deal, and they are family. And once a week, I think I address pets specifically in a will or a trust. Yeah.
Huh. Some good people in this world. It's good to know. So, going through this, you clearly have a working expert knowledge on this, and you can talk about it all so smoothly. For me, as someone who's learning, who doesn't have I don't have very complicated assets, pretty straightforward at this point. Is there a certain threshold when it comes to the complexity of your assets that you would recommend going through a professional when it comes to setting up your will versus maybe just finding a tool to do it yourself?
Yeah, well, certainly if you had federal estate tax issues, which is right now, you're passing more than 13.61 million to non-charitable beneficiaries on your death. That would be something you'd want to definitely consult with somebody about. If you had kids and we wanted to make sure that they didn't have control of assets on their 18th birthday, and too much too soon means they're going to change their life trajectory. They're not going to go back to school. They're not going to start a career. They're just going to rely on this nest egg that they have. That's kind of an automatic, you need a trust, and you should be talking with an attorney about, here are the factors that come into play when choosing a trustee, the person who's going to manage the money for the kids, versus the guardian who's in charge of the decisions for the kids, things like where they're going to live, where they go to school, consenting to medical procedures, and whether that should be the same person. And for those things, the algorithm on a website isn't necessarily going to clue you into the types of decisions that go into actually coming up with a person who's going to be in charge to make it in the documents. And I don't know that it's necessarily ever strictly tethered to how much you have, because it doesn't take that much to trigger probate. But I would say, obviously I'm an estate planning attorney. I prefer that people come to me than to do the website will, because people come in with those and they want me to look them over, and I say, I prefer my forms, and I think we should make this more bulletproof. But in some cases, for passing assets, as long as you have beneficiary designations on everything, you can avoid probate. So if you said, I've got this one person in mind that I'm going to leave everything to, if you can put a beneficiary designation on every one of your accounts, then nothing passes through probate. Where you might be more concerned with doing that is a power of attorney and a medical directive, right? So if you're in an accident, you're not gone, you're in an accident, but you're now incapacitated and you don't have the ability to make medical decisions for yourself in a clinical setting like a hospital, and you can't manage your affairs. So who's going to shut down the apartment? Who's going to pay the bills for your care, deal with insurance, etc.? So the alternative to having those documents is that a family member has to petition the court to strip your autonomy away from you in favor of a guardian and a conservator. And it's a pretty drawn out and can be expensive court hearing process, invasive too. But those forms, right? Virginia has kind of a standard state sample form for the medical directive. And a power of attorney is kind of all over the place. But I'm sure you could find a form out there, with LegalZoom that would be sufficient. Although I would say each financial institution, right, they're going to prefer their own forms, but they have their own forms. Mm-hmm. So if you bank with one of the big banks, you ask them for their power of attorney form and you fill that out and you name someone, then you're good with that bank. They're just checking that it was filled in validly and it's in their system on the account, right? So where the powers of attorney that we draft, they're called general powers of attorney. So it's kind of a catch-all, and it's things that you wouldn't think of, like changing your address, checking your mail, things that aren't authorized technically under federal law, or checking your emails, right? So electronic communications, all these things are covered within a power of attorney. Oh. So my feeling is everyone should go through this planning, whether it's on LegalZoom or they have an attorney, however you can do it. It's a good exercise. It's an important exercise that could save family members some grief. They'll have grief in another way, but additional grief. Yeah.
So let's say someone is starting completely from scratch. They don't know where to begin in this process. What would be the first step, and what would the expectation be as far as how hard it's going to be just to get the ball rolling on this process?
Yeah, generally I think people talk to friends, relatives, and neighbors. Who do you use for estate planning? That's kind of how we get our clients exclusively, is just word of mouth. So someone will come in and say, oh, I met with my neighbor, or I talked to my neighbor. Who do you use? I need to make a will. And say, oh, go see Drew. And we schedule an appointment. I have them fill out a questionnaire, and that's kind of just basic family information. So whether we're talking about children, they're married, because there are different tax considerations if you're married, just a basic asset snapshot. So one is, okay, do we have estate tax issues? Very few people have estate tax issues. But the other component of it is, okay, are we addressing every type of asset that we have? So do we need to do a certain type of deed for real estate? Do we have real estate out of state, out of Virginia? Do we have beneficiary designations on every single one of our accounts? And so that is almost a checklist for coordinating with the documents that I do. Is, okay, you can do a will, that's great, but it's going to go through probate unless you have a beneficiary designation on it. Once I sit down with someone, and it takes about an hour to go through all the different questions. I gave the example of the trustee and a guardian. If you had minor children, right, you need to name a guardian. You can only do that in a will, but should that be the same person as the trustee and the different considerations? So after roughly an hour, I have enough information. And sometimes, people might not know exactly who they want as their executor. They might not know who they want as their agent under the power of attorney or to make medical decisions, but they haven't talked through these things before, and it's just giving them food for thought, right? So however long they need to come back, and I always say, hey, I haven't heard from you for a couple of weeks. Have you given any thought to some of these decision items? But once I have everything I need, I can get drafts out in a couple of weeks. And then it is kind of a major roadblock for people mentally, I think, when they get a stack of paper in the mail and it's 60 pages worth of legalese. I try to give a really good summary that just distills it to the most important kind of basic overview. Here's the structure of it. Here's what your plan is. And here's how things would work. But, any questions or changes before you actually come in to sign, we can talk through. I have follow-up Zooms all the time and phone calls. So how long does it take is kind of an interesting question, because the very highly motivated people, and in that case, sometimes it's, I'm going on an African safari in 2 months. Well, they're very motivated to look at everything and have questions so that we can finalize in 2 months. And some people have a very difficult time just emotionally thinking through all of these decisions. It's, if I'm gone, who's going to take care of the kids? Or if the kids are gone, who does everything go to at that point? And some people have a difficult time with that. So I've got some projects out there that are 5 years old, and I'm still saying, hey, how can we? Most people aren't. Most people are more motivated than that, but it just depends. But you could have a will in hand, signed within a month of meeting. It's possible. It's not that common, but it's definitely possible.
I think I'm one of those people who I've hesitated because you do have to face your own mortality as you're going through this process. So I'd say for me, it's that, and also just the unknown of the cost of going through the process.
Yeah.
Is it still valuable for people at all income levels to consider? And
it's definitely, when you're thinking about any attorney, using any attorney, it's more expensive than something like the LegalZoom is going to be, right? But whenever you get a fee schedule from a law firm or an attorney, there's always some discretion there to reduce the fees, right? So, and we have a good sense when we meet with somebody, how complicated will this be? Somebody with $40 million needs a very complicated plan and several trusts potentially, right? So we know, well, that's going to be more than just a simple will. This is an unmarried person. They need a will. They just need the basics. Well, it's not going to be LegalZoom, but it's not going to be several $1,000s, right?
Awesome. Well, that's really good to know. So once the will is in place, the estate is in place, and all of the things that you've talked about that are included in, I think, going through an estate attorney, which is just so beyond the simple will. How, once you have that in place, how easy is it to make changes once it is in place?
Yeah, sometimes I have a couple with young kids, and 5 years after I do their documents, they say, hey, we have concerns about the guardian that we named or the trustee. We think we want to swap it out. Well, if there haven't been any major changes in the law that required drastic changes to the form, then it's easy enough to just kind of save a new Word version, swap out a name, and they print it and sign it again. Honestly, the hardest part about it is getting them to come in, finding a time to sign, because it needs to be notarized. And people don't want to go to the bank to do it, because banks won't provide witnesses because they don't want, if it came to it, they don't want witnesses to have to be in court all day. But we do, obviously, right? So, but it's shockingly easy these days. Everything's computer based.
Are there? I was personally curious about this. Are there any situations where you wouldn't recommend someone to have a will? I was thinking somebody who may be in massive debt. Is that? And this is just a personal question. This doesn't even have to be on video. I was just very curious about that.
So even then, you still want to, even if you have no assets, if the cost of having the will prepared isn't an issue, it makes sense to have a will, because you name an executor who's going to be able to close out your final business, let's say, or has the authority to pay whatever bills you're able to pay, and then your name is kind of off the books, right, at that point. And it's a lot easier to name an executor in a will and just make an appointment with the courthouse to record the will than it is to qualify as an administrator without a will, particularly if there aren't clear family members who would be that person. So I don't know if I would ever recommend someone not have a will proactively.
All right.
Yeah. But one important thing to keep in mind is you don't really inherit debt. So it isn't like, your estate has a value of negative 20,000. Well, just because you have a will and you leave everything to someone doesn't mean you're leaving them that debt. But it can be a tricky process to navigate when you have some assets, but not enough to cover all of your debt. And the law has pretty specific order of who gets paid first. So, and that is tough for people to navigate themselves without an attorney. It's possible, though.
Okay, so now let's talk charity because we're at the Community Foundation. And so, again, it's National Make a Will Month, and I know that we are involved in wills somehow, but I don't know 100% how that looks. So I was just curious, like, what role does the Community Foundation play in being part of a will? If I'm looking to leave money to charity in my will, what's the benefit of doing that part through the Community Foundation?
Yeah, I mean, I think it just makes everything really organized and just simplifies the process for the executor or the trustee who's dealing with everything. It also makes planning a little easier too. I actually last week had a situation where a client had an investment account that was designated to 10 different charities. And I was on a call with the financial advisor, and he said, this is going to be a nightmare to have each one of these charities separately fill out the paperwork with me and then divide everything into try to divide these shares into partial shares. So if they had used, and I suggested this to her, if we went with a legacy fund at the Community Foundation, everything can go to the fund and it's handled through you guys. And if there are changes on the thinking of these 10 charities instead of equal, I want to distribute it a little more heavily to these charities, or I'd like to swap out a few charities, then that process with you is really easy, and it doesn't require formally amending your documents or even changing beneficiary designations on an account, which even that involves getting the tax ID numbers for each of the organizations and their principal office address, and it's more complicated than you would think. So there's a big benefit, I think, to streamlining with the Community Foundation, and that's a recommendation I give all the time to clients.
Awesome. Yeah, you heard it from Drew right there. This has been wonderful. I'm learning so much about wills, about estates, about the Community Foundation. This has all been so helpful for me personally. I hope it's helpful for anyone who's watching this. Before we close out, is there anything that you wanted to add that we may have not touched on?
I don't think so. Check those beneficiary designations. I think a lot of people, if this is my PSA, is people have this moment of relief when they sign their wills or their trusts and they say, all right, that's it, I'm done. But the beneficiary designations what will save people a lot of grief. So everybody check those designations, and whether it's with an attorney or LegalZoom or something similar, just do the planning.